Well, now we've moved on from the initial shelter care to the response area. What takes place, Ann, in the response segment of the hearing process?
Well, the response hearing is usually the third time that the parents have come to court. And this hearing, which sometimes takes place at the initial shelter care hearing, sometimes not, is where the parents, through their attorneys, have an opportunity to tell the court whether they are in agreement with the establishment of a dependency and they will engage in services, or whether they are opposed to a dependency, that they don't wish the...
I mean, these laws have been around since this video, so I'm going to go ahead and correct her. Basically, the parents have to agree. This is all it says. It does not say that they can disagree. Okay, so she's full of shit. Okay, so the parents have to agree. Nowhere in this section that dictates the entire hearing of the fact finding. Okay, this little tiny section right here, that's all it is. RCW 1334-110, the parent, guardian, or legal custodian understands the terms of the order that they have signed and agreed to, basically. Okay? It does not say the parents can contest anywhere in this section. It does not say trial. It says hearing. That means the parents have to agree. And in the very last sentence, it even says the parties need not appear at a fact-finding or dispositional if they are all in agreement. So basically, that means they have to agree. Period. Okay? It does not say anything like, oh, if the parties don't agree, then we get a trial. That's what it would say here if it were allowed. It's not allowed. No trials happen here. They're all agreed orders.
Justice system. They don't wish DSHS to be involved in their family life. In the latter case, a trial is set, which is sometimes called a fact-finding hearing. The parents have a right to have that hearing held within 75 days of when that petition has been filed. A lot of folks think 75 days is quite a long time, but I can tell you that for preparation of a case and for a trial, it is not a long time at all. In that 75 days, we are going through the case file we get from DSHS. We may interview people that the parents have given us names to.
Okay, I know this is an old video, but this law was this way when this video was made, so I'm going to go ahead and correct her again. They can only remove a child from the child's home after the fact-finding hearing, unless the child is abandoned, which is what the Juvenile Court Act was made for, but the parent has to agree with the order first before the child is removed from the home, and that's what it says right here in the law. So she actually does not know what she's talking about. Okay, the child has to be abandoned in order to go into shelter care, and the parent has to agree to the order in order for their fact-finding hearing to be agreed and the child to be removed from the home. Okay, so shelter care only happens if the kid is truly abandoned. And there are times where parents actually sign and agree to the order if they want their child to go to a foster home, if they're homeless or running away, or for whatever reason, for drug treatment, whatever. Juvenile is delinquent. There you go.
Contest some of the information that we've seen in the case file. We may even be back before the court to ask for funds for professional witnesses such as psychiatrists, psychologists, or counselors.
Mm-hmm.
The reason they made this video is because there are no laws on it, and they have to explain it to the public in order for them to understand, because they don't have the laws they need. Just FYI.
Okay.
If the parent comes in at the response hearing and indicates that they are willing to engage in the service plan and wish to agree to the dependency, then it jumps straight down to the dispositional hearing.
And what is happening, Commissioner, at the dispositional hearing?
Well, the dispositional hearing is the first time that the parents, in a formal setting, hear what the department thinks are their deficiencies and their needs and the services that are going to be afforded them, so they have a plan to go forward and engage in a variety of services. Frequently, they're more than they can handle at one time. And I tell them that because we have a review within 90 days after that dispositional hearing to see how they've gone. I tell them there's no way you're going to be able to complete everything on this plan, but I expect you to be substantially engaged in everything there and making substantial progress.
Okay, these laws were all the same on this day too when they made this video. Basically, there's no such thing as parental rehabilitation anywhere in this set of laws. It's all juvenile rehabilitation. If you read the titles, it all has to do with juvenile rehabilitation. They cannot order parents to do anything. It does not say that they can in the law, then they cannot do it. This is all for juveniles. Juvenile, when parental consent is required, inpatient mental health, release of records, dependent children. Come on, seriously, none of this says parents go to treatment. Nothing, no laws whatsoever. This is all coming out of their mouth. That's it. This is not written in the law. They cannot do anything that they're not authorized to do by statute, and judges especially. So he's making up his own laws, basically, forcing parents into drug treatment, because nothing in here says a parent has to go to drug treatment. It has to say that in the law, and it does not. So he's a liar.
And the parents may well take issue with some of the points or services raised by the department. Generally speaking, that's not the case, because generally speaking in our county, Ann may disagree, but I think generally speaking most of our dependencies go by way of agreement, because the handwriting is on the wall, because there's a significant drug alcohol problem in our community, and that's hard to ignore when there's a urinalysis test that says you're positive for meth. I mean, that just...
Okay, but every single one of them have beer and liquor in their fridge. Really, really, really. Don't let them fool you. They can't take kids for drug use, okay? They rely on trauma, and that's what he says right now. He just admits, basically, they better do it. They're punking people for their kids, basically. That's what he just said. They better do it or else, okay? No law says that a parent has to do squat for CPS. They would have that law tattooed on their fucking arms, okay? These people are full of dog shit.
There's not much dispute about that. So the parents are presented with these facts, and they're told that you need to go get an assessment, you need to go engage in this service, you need to engage in the parenting plan, you need to engage with the parenting classes or the counseling services or whatever. And they're set forth with that. They're asked if they agree or disagree. Ultimately, I decide what they're going to do, but that's the purpose of the hearing, and usually it's something that they tell me that they're anxious to get involved with. The proof is in the pudding as we go through the dependency.
I hate to break his heart, but there's no appeal, and it says that there's no appeal to a termination. If there's no appeal to a termination, like it says right here in the law, there's no appeal, because the parent shall have no right to stand at any legal proceeding after the termination order is filed. That means there's no trial. If there's no trial, that means they're all agreed orders, every single one of them. It has to be that way, because they're not just going to terminate a parent's rights and not let them appeal, right? They're pretending like they're allowed to appeal. They're not, because there's no such thing as an appeal under the law. They have to follow the law first. That comes first before their brains, okay? So their brains don't, create laws. Sorry.
And prior to the dependency dispositional hearing, we do what's called a 30-day staffing, which is held about 30 days out from filing of the dependency petition. Parents are invited, guardian ad litems, foster parents, grandparents, if they're in relative placement, they're oftentimes invited. The parents' attorneys are invited as well. And we sit down at a table and just kind of talk about, this is what the department would be recommending to the court for services, and this is why. Are there other services that you think that you could benefit from in order to parent your children or child? What are the needs of the child? And we get input from the foster parents at that point and the parents, because there may be issues that we're not aware of at that point in time. And the ideal situation is that Ann and the other defense attorneys would have a copy of that 30-day ISSP prior to the response hearing and have had a chance to go over that with their clients.
Now, the ISSP is the Individual Service and Safety Plan. That is one of the forms that is linked to the website this evening, and we would encourage you to download that, because as foster parents, you are eligible to receive portions of that. The portions that pertain specifically to the biological parents, that would, of course, be confidential information, and that would not be something you'd be privy to, but the rest of it you certainly should have. And so the worker generally will notify you that this hearing is coming about, or this 30-day staffing plan and planning meeting, and this form is something that you should be familiar with. So then now we're at this juncture. John, from the AG's point of view, when you look over an ISSP, What are you looking for? What are some of the real salient issues that you want to make sure are addressed in there from a legal standpoint?
Well, you want to make sure that the services are reflective of the facts. I mean, here we've got a case where a child has some bruising. I don't know if we've been able to determine at this point what was the cause of that. Was that the live-in boyfriend maybe that did that? Was it just neglect by the mother and the child hurt himself in that manner? You want to make sure that the allegations that are listed in the petition and that are the concerns of the parents are going to be reflected in the service plan for the parents. I think it's also important to note that in a dependency, the goal is reunification. That's by statute. I mean, you get some real serious fact patterns that come in that never cease to amaze us, but
That guy's full of shit. The word reunification does not even exist under any title of any section of this chapter. Reunification is not the goal. It has to be termination because the word "and" is right here. Dependency and termination means that termination has to happen. That means they want to terminate your rights. That's what that means. They have to. That's the only result. Okay, concurrent planning. Termination runs concurrent to what? Adoption. Duh. See, I've been here for too long. That's why I can talk like this. Most parents are too traumatized to talk like this, and that's what they bet on. That's what these losers bet on.
The goal is reunification. You're trying to get these kids back with the parents if at all possible, and to do that you need to make sure that the services that are recommended by the department and sometimes...
That's a reasonable effort.
Right, right.
Well, I also think it needs to be said at this point, however, that that's not always the way the parents see it. They see this as the state taking their children away. And very oftentimes it's that adversarial relationship that permeates this process, and they simply do not understand why the state has done this. A comment that's often made is there are many worse situations out there. Why don't they go take care of those instead of harassing me?
Okay, no, they're wondering why you did it because it doesn't say in the law that you can do it. That's why.
The ISP that you just spoke about is also issued in a 30-day staffing, at which point a trial may not have yet taken place. So it needs to be understood that if that service plan comes out prior to the trial, the parents may not be ordered to do any of those things. That sometimes creates some complications where different parties expect these parents to be engaged in that process when there's really no requirement that they do that at that point. After a trial or after they agree to the establishment of dependency, then this ISSP would indeed be the basis of a court order and they would be required to perform those.
Now, the reason we do it 30 days out is just in terms of time efficiency so that we're ready, that we have this information prepared.
Well, and I think that we're looking at this, these are the issues that we as a department see, and these are the issues that we are probably going to recommend to the court if dependency is found. And I think it is stated at the 30-day staffing that there is nothing in place that orders the parent to do any of these services. This is what we as the department see that could address some of the risk factors that led to the removal of the child. So I think that it's a way to engage the parent in identifying some of the needs that they have and their children have.
And the goal is to move it along, excuse me, Deanna, move it along as quickly as possible, obviously. So if you're getting the service plan out there as soon as possible, it's like, here's what we see as problems. If they agree with that, that's great. If they don't, then they have the right to go to trial. But at least they know where they stand, what problems that the department sees that they need to correct.
One thing I would like to go back a little bit, in particular with this case, but oftentimes at the initial or even further shelter care hearing, we train our CASAs to look at permanency planning from that point on. And I think the department has trained workers to look at permanency planning for children from the very first contact. And part of that, and one piece of that, the court addresses in asking the parents for any relatives who might be potential placement resources. not just for the long term, but also short term. There's also asking the parents if they have any Native American status, because those issues need to be resolved earlier than later, and if they're not addressed earlier, they need to continue to be looked at throughout the life of the dependency, because any one of those factors can slow the case down in terms of permanency planning. So I just wanted to go back to that. And in this particular case, for instance, with Tim, he does have a father in another state, and the CASA or the GAL, I'm sure the department has already done this, but we may be asking early on for an interstate compact to look at this father before we get too far down the road in the dependency.
Mm-hmm. And would someone like to address what interstate compact is so that our foster parents know what we're talking about?
The interstate compact is basically a process that there's a working agreement with this other states. If we have a parent, in this case Steve, who lives in another state, we have to complete what's called an interstate compact placement request. Once we have a court order that places the child into care, that process cannot be started until we have that. And the packet, it's a whole packet of information that gets sent off to headquarters in Olympia, who then sends it to the state headquarters where the parent resides. And then it gets sent out to the local office, where they would do a home study of the parent and assess whether it would be an appropriate place for a child to be placed.
So would it be correct then in saying that one state may not place children in another state without that receiving state agreeing to and feeling comfortable with accepting the ongoing supervision of the case?
Correct. That has to
Actually, it's a
happen.
little bit more the other way around. This state would not be willing to place this child in another state until we had things hooked up in the other state, which implies their acceptance.
Right.
And, you know, there are 50 states in our union. And as you would expect with 50 states, there are 500 different reactions from different offices around the country. And in some areas, one caseworker will have far better response from a different jurisdiction than another caseworker. And I won't dwell on history, but there are 50 different states.
Some work quicker than others.
And it is a long process.
Yes.
And sometimes it takes many months to get a response from another state.
And you can see the problem in a dependency on Tim, when you've got a father that's out of state that, as Ann said, is a pretty good guy. You're trying to get all this in place at the same time. If Ann is representing that father, she may not want to agree to the dependency because we're alleging that there's no parent capable, and maybe he would be capable had the geographic boundaries not been as they are.
Now, is this an appropriate place to bring up alternative measures for Steve? Were he not, wanting to allow this dependency process? Actually, the dependency process supersedes any kind of third-party custody, correct? In other words, Steve couldn't go into Superior Court and say, I am this child's biological father, I would like to have a change in the parenting plan.
Under the laws of the state of Washington, any other action concerning a child except an offender matter, a criminal matter, is state. You just can't go there. I have exclusive jurisdiction in the dependency, and to the extent that someone wishes to pursue legal custody, if you will, through a parenting plan or a guardianship or a third-party custody or something else, they must come to the dependency court, persuade the court that that's an appropriate thing to do. Not only is it appropriate, but it is appropriate at that time in the dependency, which generally speaking at shelter care, it's not, because we don't even know what's going on yet. But maybe later on, as we're moving towards permanence, that might be a more appropriate thing.
Now, representing Steve, who's in this other state and for whom there are no allegations of abuse or neglect, I may approach the court at the point of the response hearing, prior to trial or after trial, and ask for something that we in this county call concurrent jurisdiction, which would allow Steve to go to the family court where either in this state or in his home state, and that may be different depending on his situation, and get a change of custody or to establish a parenting plan or a custody order. And if that did occur, at that time, I would probably make my pitch to the Attorney General's office that this case should be dismissed.
And it very well might. I mean, if you've got a guy, we've had fathers from out of state that'll show up in Kitsap County. They'll hear about this situation. They'll show up and they'll demonstrate that they've got no problems. They've got a support system there and relatives, and it very well may be a way that the state can get out of this family's life and put the child in a safe situation.
Now, on the other hand, if I'm representing Stacy, this is a serious problem, because once her child leaves the state of Washington, you can guess the chances of her having that child come back to the state of Washington, especially given the issues that she's facing.
Right, right. So would you then be leaning on her in terms of jumping through the treatment hoops and doing the things that you think she needs to do?
And not only to jump through hoops, but to actually learn something and
make some change.
Make some real change in her life, because that may be the only chance that she has of keeping this child with her.
Right. Commissioner, if it doesn't, if this is not something that can be agreed upon, tell us what the court looks like in terms of fact-finding. Who hears that? Is there a jury? Let folks know what that's like.
Well, first of all, the fact-finding is formal, Perry Mason style, for those old enough to remember Perry, trial. I mean, the rules of evidence apply, procedures are there, and it is a formalized process. It is the only formalized process in the entire dependency process. The shelter care process, the rules of evidence do not apply. The reviews, the rules do not apply. The dispositional hearings, the rules do not apply. And it's basically up to the discretion of the court as to what information I think is relevant and germane, and what I'll listen to and what I won't listen to. So it's really a significant event. It is conducted in our county by the judges, and it is conducted as a trial. We schedule the trials. 75 days is the limit on when they can be conducted, and they are conducted at the courthouse in a courtroom. They are closed hearings because these are confidential matters, but they are conducted before a judge with the bailiff, or not the bailiff, the court reporter and the court clerk there. There is not a jury. It is exclusively a judicial determination as to the best interests of the child and whether or not a dependency should be established. And that's the focus of the fact-finding. The focus really shifts over to the parents and whether or not the state is able to prove that the parents have either done the abuse or the neglect, or they're not able to provide for the care and safety of this child. They have to prove that by what's called a preponderance of the evidence, which is more likely than not 51%, and that's the standard of persuasion that the state has. In other hearings, when it comes on for hearing, for instance, if they wanted to do a termination of parent-child relationship as part of the permanent plan for the child, that's also a formal trial. The rules of evidence apply and so on. But the standard of persuasion there, because it is a more significant act that is being sought, the standard there is by clear, cogent, and convincing evidence, which on a scale of things, you start off with preponderance, which is the normal civil standard. That's what fact-finding is. You move to clear, cogent, and convincing, which is more than a preponderance, but not quite what a criminal standard is, which is the beyond a reasonable doubt. So it's a major event, and it causes Mr. Long and Ms. Montgomery to jump through all the legal hoops.
Correct.
On Indian child welfare cases, the standards of proof are higher.
That's clear, cogent, and convincing.
Beyond a reasonable doubt
For termination? Okay. But in terms of fact-finding for the dependency, would that be, what would the standard of?
Clear, cogent, convincing,
And convincing.
on the
Okay,
fact
thank
finding.
you.
So it's still higher.
Okay. And so then let's just take a look then at where we are in this process. We've now moved beyond the fact-finding. Say we may have had an agreed dependency, and the case moves on from CPS, Child Protective Services in this state, to a more long-term case manager with Child Welfare Services, correct?
Correct.
And then what happens from there?
Typically, cases are moving from Child Protective Services, who do the initial investigation, to ongoing Child Welfare Services at about the 45-day, anywhere from 30-day staffing on to when the dispositional happens. The role of the CWS worker is to work towards permanency for kids, whether that be the return home, adoption, third-party custody, guardianship, whatever the permanent plan is identified as. And the department is really working at return home of the child if that is possible, but at the same time they're doing concurrent planning so that there's a backup plan. If, you know, something happens that a child can't go home, what is the plan going to be? Is it going to be adoption? So there oftentimes is two plans going at the same time.
Right.
And so typically the case will stay in CWS, Child Welfare Services, until the permanent plan is achieved, whether it's dependency dismissal, a child becomes legally free, or a guardianship is established.
And this is a very difficult piece, I know, for foster parents, because particularly those who come into our system with the idea of adopting, foster adopt, this concurrent planning that we do, which we have to do, I've heard it described by somebody from Children's Home Society as legalized schizophrenia, because you've got these two plans going. At one time we asked the foster parents to open their hearts and homes, love these children as their own or almost as their own, and then there's this roller coaster while we work to return that child to the bio family. Talk to me, as the president of your Foster Parent Association, it's a very active one, what are the kinds of things that you hear from folks in that role?
Well, it's clearly frustrating for a foster adopt parent who is primarily in foster care to adopt a child for whatever reason. And they find, you know, they wait for the day when that child is legally free so that they can actually start the adoption process. But getting to that process, sometimes all these players here affect the parents, and the parents affect the players, and that child is the ping pong ball that goes back and forth. So unfortunately, the foster parents are in limbo, and the child's life is in limbo, trying to figure out when the parent is going to come on board and get their act together, do the things that are required of them if they ever want to get that child back. And sometimes it happens, and oftentimes it doesn't. But the process can be really frustrating for the foster parent who wants to adopt that child. In the meantime, that foster parent has become thoroughly involved with the child. The child has become, especially when they're really young, sometimes they're taken from their parents when they're just a week or two old. And that foster parent nurtures them and raises them and their mommy and daddy. And then sometimes, way too long down the road, that child is taken away from them, and now they have a new mommy and daddy that doesn't have a clue what those kids are about. And they have to start all over, and the kids are, actually, I think they're severely affected by it. So the faster it happens, the better, one way or another. The adoption process is clearly not going to ever be perfect. There is no process that's perfect. Foster parents, above all other people, and I don't mean to sound like anybody sitting here is callous, but foster parents, more than anybody, live with these kids day and night. And they have them cry and tell their fears and their sorrows, and they watch their behaviors. And it doesn't matter how badly a parent has abused a child, neglected the child, or mistreated it, that child always loves their parents and always has a dream of going back home, even if it means it's going to kill them, because that is the connection that you cannot ever break. And the courts have a difficult job of taking that child and putting them where they're safe and when they can nurture and survive, and that's what foster parents do. And sometimes we get our hearts broken too. We don't get to keep the kids, or sometimes they move on, or sometimes they don't thrive in the situations because of what's been done to them.
What role do you see, Commissioner, the foster parent playing in terms of apprising the court of what's really going on with the child? How do you like to have interaction with the foster parent? Is it in written form, coming to the hearings? What types of things do you look for?
Well, first of all, people need to understand that I'm seeing the case in that particular Monday or Wednesday morning on the calendar. I have the ISSP, and I have whatever the lawyers have given me. I have whatever Ms. Bedell might have, or the CASA that's there. And basically, that isn't much in the greater scheme of things. And I'm there to review what's happened in the preceding 6 months, 3 months, or whatever my review cycle has been. And sometimes I'll have more frequent review cycles. The foster parent, in my judgment, plays a very key role in that process, and they are always welcome in my court. They have a right to have input to the court, and that comes in a variety of forms. The forms that I don't take a phone call, and I don't take emails from them because that's ex parte communication, and I can't deal with that ethically. But I do take letters, which I then make copies of and distribute to all the parties. They can come to court, and I will ask them if they're in court, if there's anything they'd like me to know about it, and then they're free to tell me anything they want, subject to the same parameters I impose upon everybody else. That is relevancy and being germane to the issues. But the foster parents are a very key word to be heard as to what's going on with a child. And in fact, I can think of some cases where there was a suggestion that a child leave the state of Washington and go elsewhere, and the foster parent was very persuasive that that should not happen, at least in the parameters time-wise that were being suggested, because of the impact on the kid. And so we didn't. So I think they're very, very essential to the process.
And I've been before you and had you show a keen interest and ask me, you know, do I have anything to say on behalf of the child or the case? And it's really important that any judge can hear what the foster parent has seen. When that child turns up at your doorstep, and we take teenage boys, so when I call them children, they're not really children. But when they come to you filthy dirty, they have lice in their hair, they don't have any clothes that are worth keeping, they haven't had a bath, they haven't had their toenails clipped, their fingernails clipped, they need a haircut, they're malnourished, and they still love their parents. Make no means about it. They've learned how to roll drunks in parks, steal food from grocery stores. They've learned some outlandish behaviors, and when you hug them, they cry and they scream and they run away. But if you chew them out and you get in their face, they take it stoically like a soldier. You got to be able to take that to the judge and say, these parents have damaged this child so badly. And a foster parent is not the best friend of a bio parent, because we're the recipients of what they have bred. And so sometimes we're not very understanding, and we really don't care what their excuses are. All we care about is that kid and trying to salvage him so that he becomes a productive, decent human being in our societies, because we're surrounded with a lot of people that tear up kids and spit them out over and over again, and we've got to figure out how to try to make them whole again.
And that's really the real dilemma, isn't it, in terms of the concurrent planning, that, you know, we in the department see you as our right hand. I mean, we can't do what we do without you. And so, you know, we hear your frustration because you see that child come back from visitation being upset, or you saw that child come to you as you just described in such a disarray. And yet we ask you, in some cases, we're training foster parents to actually interface with biological parents and work therapeutically with them.
And we do that.
And you do that. And I think that, you know, we have to really give kudos to you as a group of people, because I think we ask an awful lot of you.
I've got to truthfully say that most of the time, and this is really sad, but most of the time we don't see the successes that we'd like, or at least to the degree we'd like. But I have one success that's really standing out right now was a methamphetamine user. You know, we call it Crystal. Pretty hardcore, fallen down on her luck, lost her kid, and CPS took the child, put it in foster care. Mom has done everything that the court has said, and Mom is doing great. Mom is clean and sober for quite some time now. She's doing everything, and we actually see the day that her child is going to go home. And this kid hasn't been terribly abused, which is a real thankful thing. It's going to make a beautiful family one day. It's one of those rare times when you actually feel good about what you're doing and that you know you're making a difference.
Yeah, that's wonderful to hear, because we know that
it doesn't happen often.
It doesn't happen a lot, not very often. John, would you please describe the difference between guardianship and adoption?